This session is being recorded and will be available on our website by the end of this week. Welcome to the Los Angeles Latino Chamber webinar. We are happy you have joined us this afternoon to learn some incredible golden nuggets on helping your business not to be sued. I'm Olivia Rios, Director of Operations here at the Los Angeles Chamber of Commerce, and I'm excited to be here with you along with two LAWtinas, LAWtinas, who will provide you with some helpful insights on how to protect your business in California when the laws are stacked against you. But before we begin today's session, I'd like to introduce our chairman, Daryl Salceda. Daryl?
Yes, hi. I would like to welcome everybody to the LALCC workshop. Our workshop today was 5 lawsuits that will devastate your business. I know sometimes, it's rough to pay that premium, but I guarantee you, I can tell you from experience that being underinsured is something you don't want to do. You might as well have no insurance than to be underinsured. So I would like to welcome Speaker Valerie Gonzalez. Thank you, Valerie, for taking your time to help. We have 25 participants on this call to give us your secrets. And also I want to send a special thanks to Gina Zapanta, who's going to be moderating our program and taking time from her busy day. Boy, do I know she's busy. So let's go. Take it away, Olivia.
Thank you, Daryl. And just to begin, our moderator for this program, like Daryl said, is Gina Zapanta, who is a partner at ZA Law, a workman's compensation law firm, and she is also a board of directors here at the LA Latino Chamber. A little bit about Gina. So Gina Zapanta Adler is the co-founder and attorney at ZA Laws, a workers' compensation law firm. She is also a board member on the Los Angeles County Employee Retirement Association since January 2018 to present. It is a political appointment by LA County Board of Supervisor Janice Hahn. She continues to serve as board secretary with her signature on every LA County employee paycheck, which is a $70 billion budget. She is also on the USC Latino Alumni Association, and she's on the Corporate Advisory Council since January 2020 to present. But before Gina introduces our presenter today, just want to make a few housekeeping notes. To please silence your phone, please mute yourself, be open to learning, and please hold all questions to the end of this session. So let's get started, and Gina, please take it away.
Hi, everyone. Thank you. Thank you for having us, having the LAWtinas in the house. We're happy to be here. I'm so proud to introduce Valerie Gonzalez. We recently became acquainted through the lawyer networks. And, everyone has their jokes to make about lawyers, but you can joke until you actually need one. And so I think this presentation that we're having today is giving you invaluable information up front before you actually need a lawyer so that you don't need a lawyer. So please take from it what you can, and what Valarie has to give you is stuff you will pay a very pretty penny for when and if you need it. Hopefully you don't after this. We run 2 law firms and we have a lot of employees. I've run a business in the past, and I know that as an employer and as a business owner, there are a lot of, especially HR, human resource, legal landmines that nobody has ever educated us about. We kind of bump into them as we do when we get sued or there's a potential threat of being sued. And this webinar is, I think, a perfect venue for similarly situated business owners and employers to learn. And so please, I encourage all of you to ask your questions. There is no dumb question because we are all in the same boat, and you're probably going to answer or ask a question everyone else has as well. So with that, Valarie, please take it away. Thank you for being here.
Thank you, Gina, so much. Thank you, Olivia and Daryl. I'm so honored to be here with you all today. Thank you for taking time out of your busy day to join me and everybody here to discuss this really important topic, like Gina mentioned. I'm Valerie Gonzalez. I'm an attorney here based in Pasadena. I'm a native Angelino, born and raised in the San Gabriel Valley. Prior to becoming an attorney, I had a long career as a human resources professional in corporate headquarters, hotels, retail, and various other industries. And my law firm, San Gabriel Valley Law, exists now to protect California business owners, not unlike myself and probably most of you here on this call. So I'm really excited to share with you on the topic that we have today. And like Gina mentioned, please collect your questions either in your head or in the chat. And at the end of our time together, we will go ahead and take those questions on, okay? But what would a webinar from a law firm be without a couple of disclaimers, right? So the information that I'm going to share today is not legal advice. It's not intended to be comprehensive. And you really should consult a lawyer who knows your exact situation and can give you tailored legal advice in order to help you with your specific needs. There's no attorney-client relationship here, and this is for California businesses only, which I assume most of us are. All right, are we ready? Here's our agenda. So we're gonna go over the 5 most common reasons business owners get sued, how these lawsuits will bankrupt your business, how you can't afford to even get sued for any of these for any reason, and then 3 ways that you can avoid a devastating door-closing employee lawsuit, regain some time, because I know we all need more of that, and some peace of mind. And then at the end, as I mentioned, we'll have time for a Q&A. Okay, so let's get right to it. Here we go. Here are some facts. So raise your hand if you're a business owner. Okay, raise your hand if your business is in California. I think that's most of us here. Well, here's the facts. 1 in 2 business owners in California get sued every single year by their employees. That means if you raised your hand, you have a 50% chance of getting sued this year. I don't know if you guys are betting people. I don't know if those are good Vegas odds, but I don't think so. I'm not a betting person, but I don't think those are good odds. 50% chance of getting sued. So that's only speaking about lawsuits. It's not even touching on the numerous fines and penalties that can be brought against you from governmental agencies as well as a business owner. And we'll talk more about those. Of those lawsuits that are filed, business owners will overwhelmingly lose the vast majority of the lawsuits that are brought against them. So 67% to be exact. So they will be won by the employees 67% of the time. Do you know why this is? Well, understanding why is really crucial to that, to avoiding these things. The reason why is that the laws in California are created primarily to protect employees. So that means that business owners are really fighting an uphill battle. They're fighting against laws that are created to essentially go against them. So this means a couple of things to you as a business owner in California. First, it means that you have to be more strategic now than ever to ensure that your business is protected and that a lawsuit would not absolutely devastate your business. Secondly, it means that you must be proactive in your approach rather than reactive. And thirdly, it means that as a part of being proactive, you have to begin protecting your business today. And that's really what we're going to talk about. Okay. On top of those lawsuits that can be brought against you by your employees as a business owner in California, you can also be fined and penalized by a number of federal and state governmental agencies. These agencies exist to protect the rights of employees, not business owners. Okay, so some of these agencies are EDD, EEOC, Workers' Comp, Department of Labor, Department of Fair Employment and Housing, and the local labor commissioner. Have you guys heard of these people before? I'm sure you have, right? At least some of them. Also, Cal-OSHA is another one. On top of that, as a business owner, you can invite union presence into your workplace without realizing it, which will really dramatically alter your company's culture. It'll increase your costs, it'll complicate your operation, and it'll restrict your freedom as a business owner considerably. So who's driven down the 605 freeway lately? Anybody or just me? I'm sure we've driven on many freeways lately, and really on any freeway today, you see the billboards. Is your boss being mean to you? Do you hate your job? Call us, right? All of these billboards of lawyers who are advertising to you. No, they're advertising straight to your employees, and your employees see those too. All of these attorneys, they do free consultations and they require no money down to hire them. That means that your employee literally just has to call them and they can file a lawsuit against you with very little effort. Just as easily, they can log into one of these agency websites and file a complaint against you. So there's no even lawyer required, just internet access. All right. So those are some of the realistic facts facing California business owners. And that's realistically how easy it is for your employees to sue you or file a labor complaint against you. California is a beautiful place to live and work. I don't have to tell you guys that. We can look outside and see that and know that. It's so rewarding to live here. It's so rewarding to do business here. But the fact is that business owners have extreme challenges. And after coming off of a year like we just did, I don't have to tell you guys that. We know that this year has been more challenging than ever. I know that you have experienced that firsthand, but really what I'd like to do during our time together is encourage you to challenge your own thinking for a moment as to how you previously approached business problems and the result of how you've approached those business problems. And I'd like to challenge you to think outside the box and to consider alternatives that perhaps you're not doing it the best way that you could. And perhaps there are solutions that can help you more comprehensively, better than previously what you've done. So let's get into them. The top 5 reasons. The first one, the number one reason that business owners get sued is firing an employee without a valid reason. And if you'll notice on the next slides where I highlight these reasons, you'll see in the corner these exclamation marks. And this is basically quantifying how much a lawsuit will cost you as a business owner if you get sued for these reasons. So if you get sued, a wrongful termination lawsuit costs approximately $1 million. Do any of you have $1 million to burn this year in a lawsuit? I don't want to, and I'm sure you don't either. So keep this in mind. Now, California is an at-will state. Have you heard that term before? At-will generally means that basically an employee can be fired for any reason at any time, except one that violates the law or a contract. So you can fire employees and you can do that anytime, except if it violates the law or a contract. In the same way, it means at will means that an employee can end their employment for any reason at any time, except one that violates the law or a contract. So then the 2 ways that business owners get into trouble and end up in a wrongful termination lawsuit is for firing people who, first of all, have a contract that say that they can't be terminated except for specific reasons. And then secondly, when they act in reactive ways rather than proactive ways. So I want to give you 2 examples, 2 stories from my past life in HR and also in law. But one of them happened when I was a human resources professional and I was working for a hotel chain in West LA. And when I joined the company, they were fighting a multi-million-dollar wrongful termination lawsuit after they fired a long-term employee. Now, remember, in California, can you fire employees? Yes, you can fire employees, except for if it violates the law or a contract, right? So this person was suing for a wrongful termination, saying that we fired him illegally because he had a contract saying that he could not be fired. And that when we fired him, we were breaching the contract. Now, you may say, well, that's dumb. I would never make a contract with an employee like that says they can never be fired. Well, let me tell you about this situation. The contract that this employee was referring to, that he took his employer to court over, that he wasted his employer's time over, that he sued his employer over, was a series of repeated comments over many years where his boss told the employee that he would have a job with him for life. You're such a good employee. Oh, I want you with me for life. You'll always have a job with me. Oh, you're the best. Does that count as a contract? What do you guys think? Well, it could. It absolutely could. And it has been supported in court before. And so this is now an issue before the court for them to decide if this is a valid contract. And if it is a valid contract, then they have a wrongful termination lawsuit, and this employee is going to win. Now, the second story that I wanted to share with you was when I was retained as a lawyer for a client who was right in the middle of being sued by a former employee. And I was retained to help them with a matter that kind of went along with it, but not this specific matter. But anyways, the employee was a rock star. And you guys tell me if this sounds familiar, because I think we've all dealt with this sort of situation before, hopefully not to this extent. But this employee was a rock star. I mean, they were just dream employee. They could produce high levels of work. You didn't have to micromanage them. They were excellent. They made your job easier. But in terms of people skills, this employee was an absolute nightmare. Now, the owner of the company never really saw it, but they got complaints all the time from other coworkers and even from clients. But they justified keeping this person because they couldn't afford to lose them. Have you guys been there before? Yeah, many of us had. They couldn't afford to lose them, and because they were just such a good worker. But one day the employee was rude to the wrong person. They were rude to a client who was a very valuable client, and the owner had had enough. They fired this person in frustration. So of course, what did the employee do? They sued. And when it came time to collect all of the evidence for this employer to say, you know, this person has been a nightmare, they've yelled at clients, they've yelled at employees, and we've talked to them about it, there was absolutely no paper trail. There was no evidence of this because the owner never addressed it. And so without any evidence, without a paper trail, there really is no evidence that this even happened. And so the owner, in acting out of emotion rather than acting systematically and writing this person up, addressing these problems, really set themselves up for a wrongful termination lawsuit. So tell me, has that been you? Have you tolerated poor performance before? I think a lot of us have. The second reason that California business owners get sued is not understanding and complying with wage and hour laws. So a lawsuit for wage and hour costs, again, approximately $100,000 up into the multi-million dollars. And I'll tell you why. Because typically it's not just one employee when it comes to a wage and hour suit. It's usually a class action, because if it applies to one, it usually applies to multiple people. If you're paying people wrong when it comes to overtime and calculating wages, you're probably doing it for many people. So California is notorious in this area for their wage and hour laws. They're some of the most difficult in the nation to understand and also to apply. And the law in this area is constantly changing. And it's changing based on cases. So people that get sued, and then the law changes based on that lawsuit. So what you want to avoid, what I want to avoid as an employer, is being the case in court that changes the law, either, well, to make it stricter, maybe to make it better would be nice, but that is a little bit rare. So wage and hour laws include laws pertaining to meal breaks, time tracking, classifying workers, overtime wages, incentive pay, split shift pay, bonuses, and many other areas. On top of that, every industry and many counties have their own separate wage orders employers must know and follow. So there's many nuances to them, and consistently applying them is really a battle of trial and error. The problem is that the trial and error can be extremely costly and absolutely devastating. As difficult as they are, when I worked in HR for that hotel chain in West LA that I told you about, the employees there knew the laws and could question us on just about anything. So I want you to hear this. If you have employees who have ever worked in California, ever, I mean, one job in California, they know the laws. They know the laws. So you need to know them as well. Additionally, when there's a lawsuit for this, the courts will look back and award damages for 3 or more years, depending on the jurisdiction. So again, one missed meal break for one employee can quickly turn into multiple meal breaks for multiple employees over a period of time. And then when you have those multiple employees who aren't getting paid correctly, they're not given their meal break, they're not being paid overtime at the correct calculation, that's what turns into that class action lawsuit, which can then drive the lawsuit up into the multi-millions. In 2019, the top 10 employment lawsuits in California had damages of $15 million to $98 million. And that was those were wage and hour lawsuits. So how do we comply in the area of wage and hour? Well, this area, possibly more so than even other areas, it requires constant and consistent auditing and human interaction. This is not a set it and forget it process. You cannot rely on an algorithm or your payroll system to correctly comply. Payroll systems are great tools to help you pay your employees. Okay, did you hear me say that part? Payroll systems are great tools to help you pay your employees. That is it. They are not experts in helping you comply with the law. Payroll systems don't have critical thinking skills. They don't talk to your employees on a consistent basis. They don't see them clock in. They don't know whether or not they're taking their meal break. All they know is what you're inputting into your system. So you cannot rely on them. And if you are sued for wage and hour, you can't point to the payroll system. This has already been determined in court. You can't sue your payroll system for this. This is on you. So can you really rely 100% on a system that has no critical thinking and that you can't hold responsible? I wouldn't. And I would advise that you don't as well. Reason number 3. So reason number 3 is not keeping up with the ever-changing California laws. Oh my gosh, can I get an amen? We get new laws every year, and we get them throughout the year, not just at the beginning of the year. And we have a lot of them already. So there are currently over 26 employer-specific laws for businesses that even have just one employee, just one. You have just one employee, there's over 26 laws that are specific to employees that you have to comply with. Additionally, federal law has over 180 employment laws that have to be followed. That's a lot of laws. Many business owners think that because they only have the one employee or they only have a small amount of employees, they don't have to comply with that many laws. I actually had a new client who, when I first met them, they told me, oh, you know, I'm okay. I don't really need legal help or HR help because I'm at the 5-employee rule, or I'm under the 5-employee rule. So I don't have to worry about employment laws or overtime or leaves of absences or anything like that. And I probably made that face right there. I said, what is the 5-employee rule? And he said, you know, that one where I have to give them overtime and leaves of absences and all that stuff. And I said, well, employment laws always apply to employees, no matter how many employees you have. And there's about 26 laws that you have to comply with. and you should have seen his face. But the good thing is we had each other. He had me. We worked together. We figured it out. But a lot of business owners, and you may even be saying yourself, are under the misimpression that these things don't apply to you, that you don't have to worry about them, but you do. You really do. So as you can see on this slide, having less employees doesn't mean that you don't have laws that pertain to you. The same applies with having a mixed workforce of both independent contractors and employees, which I'll touch on in just a bit. So as I mentioned, the laws are always changing in California, and this little graph shows us sort of the trend of how they change. So every year since 2019, California has introduced more than 20 new laws every single year that directly affect your role as an employer. So on top of the current ones, 20 more. And this coming year, which is in 2 months, can you believe it? We can expect an average of 20 more new laws based on that trajectory. Additionally, your industry, your county, and your business type have ordinances that you must follow as well. So these are different from the established laws that we just spoke about, and these are the ones that are introduced at various times of the year. Just in the last 4 months in LA County, we saw 2 huge emergency orders and public health orders pop up in regards to vaccine mandates and COVID-19. So I'll just say it. How do you even keep up with this stuff? How do you not spend every waking moment on Google all hours of the day? How do you not make this a full-time job where you're just simply researching all of these new laws? Not to mention, you know, how do you sleep at night trusting something you found on Google from some guy who says he's an expert, right? How do you know what all of these are, and how do you keep up? And then when you do know what the laws are, how do you understand the true meaning behind the law's creation so that you can understand it and apply it to your business in the way that it's intended? So do you know what I mean when I say true meaning? Lawyers are trained beginning day 1 of law school to not just learn the black letter law. So the black letter law means the text of the law. So for instance, there's a law that says, do not jaywalk. But lawyers are trained to understand the true meaning of the law behind the black letter. So why would our society want to make it illegal for people to jaywalk? To steal all of our fun from walking through the streets at any time that we want? No, not really. They don't want us to jaywalk so that people don't get hit by cars all over town all throughout the day, right? So that's the true meaning or the intent behind a law regarding jaywalking. In the same way, employment laws have true meanings. And by understanding it, you can understand how to proactively protect your business before the lawsuit, as opposed to just reacting to a lawsuit. Okay, reason number 4. So legislative trends indicate that workers as independent contractors is not favored. Many of you have probably heard of the gig worker laws that companies like Uber and Instacart are currently fighting. California has repeatedly attempted to require these companies to make their drivers for companies like Uber and Lyft employees rather than independent contractors. And we know that Uber will likely lose this battle because it's pretty obvious that California wants them as employees. And why would they want them as employees? Well, when you have employees, you have employee taxes, workers' comp insurance, and a whole host of other things. In the past 9 months alone, new laws have been passed which indicate that California is continuing to move away from classifying workers as independent contractors in favor of making them employees. So independent contractor status is reserved only for a select few and should not be the default for business owners to hire workers. If that is your default thing to do, I need help in my office. I need help on a job site. I need someone on the construction site. So I'm going to hire an independent contractor. If that's your default, I would strongly encourage you to steer away from making that your default until you've consulted with an employment attorney. Because as it stands right now, there are only a handful of jobs that the law says qualify as an independent contractor. There's only a handful of those. The others that may qualify as an independent contractor require an evaluation of the job duties, and it also requires applying a 2 to 3 part legal test by an employment attorney. So I actually had a business owner call me last year. He was employing someone as an independent contractor who got hurt on the job. The first thing the person did was sue the business to fight that he was really an independent contractor, but rather he was an employee. If he wins that, then he files a workers' comp claim to get paid for his injuries. The problem is that this business owner, because he thought he was employing independent contractors, didn't have workers' comp insurance. And so if he doesn't have workers' comp insurance, and the guy is an employee, if the law says that, then the labor commissioner will order this business owner to stop operating. He's going to fine him on average $2,000 to $10,000 per penalty. And if he doesn't comply, it's criminal. It could be a criminal misdemeanor. So that's a bad day, needless to say, right? The message is get your stuff reviewed by an employment attorney before you just act sort of on autopilot where you're defaulting to things. Okay, reason number 5. So reason number 5 is not understanding reasonable accommodations. And this is a big one. You probably have heard this term lately. It's a very hot term right now in regards to vaccinations. So this is what a reasonable accommodation really means. It's governed by the California Fair Employment and Housing Act, and it requires business owners with 5 or more to provide reasonable accommodations to individuals with physical or mental disability, or for religious reasons, unless it would cause an undue hardship. So that's kind of the wordy sort of explanation, but let me break it down. So currently, there are only 2 reasons an employee can request an accommodation, excuse me. The first is due to disability. The second is due to religion. An employer only has to or does not need to accommodate them if it would cause an undue hardship. Now, that term undue hardship is a legal term. It's not a preference. So a legal term should be reviewed by an employment lawyer to really assess if this person or this situation qualifies. And it's very fact driven. So let me give you 2 examples of how this could or could not apply. Say you have an administrative assistant. They don't see clients, they work at the office, and they request to work from home temporarily as an accommodation for their medical condition. They already have the equipment to do so. They already had a laptop, but they don't have a phone. Could you accommodate that? Yeah, you probably could, right? Buying that person a phone or paying their phone bill during that time could be an accommodation and probably wouldn't be an undue hardship. But really, it depends on what their job duties are. If part of their job, an essential part of their job, is also seeing clients, then it could be an undue hardship. So it really does depend. Now, on the flip side, what if you're running a store and you have a cashier that requests to work from home? And a lot of our workers are requesting to work from home due to COVID, right? So if a cashier in a store requests to work from home, do you think they could, ring up customers from the comfort of their own home? Probably not, right? So that would probably be an undue hardship because it changes the nature of their job and of your business. And you can't really have customers swing by the employee's house to check out from the store, right? It's kind of silly, but it can be as basic as that. When it comes to religious exceptions or accommodations, This is touching on issues of constitutional law. And if you watch the news, you hear a lot of this right now with the vaccine mandate, you know, the Constitution. So they're not wrong in the sense that this is a constitutional law issue. And so if you're dealing with issues of constitutional law, you need an attorney to help you with that. This is not something that you want to be in the news about or in the courts about for violating the Constitution. The point is that reasonable accommodations are very fact-driven. No two scenarios are the same, and they're really a case-by-case basis. So you need to have someone that you can turn to and call and ask these questions to. I had this question. I think I can accommodate it. What do I need? And then that lawyer can tell you, well, you need to collect these things from this person. This will cover your bases as a business owner and protect you if they say you didn't accommodate. Also, on the flip side, you don't have to accommodate everything. So a lot of my clients, when I meet them, there's two clients. There's the ones who operate like the wild west, and they're just doing all kinds of things. And when we meet, you know, there's a lot to do as far as helping them comply. But then I have other clients who are so scared that they're just letting their employees do whatever they want. They're accommodating everything and they don't have to. But the only way they're going to know that if they have an advisor who is an expert in employment law, who is going to advise them that they don't have to accommodate everything. They don't have to let their employees run all over them, and then give them practical options for how to sort of navigate that situation. All right, last little thing about reasonable accommodations. Even if you don't have 5 or more employees, it doesn't mean you're scot-free. It doesn't mean you don't have to accommodate reasonable accommodations. Because the law favors reasonable accommodations, whenever it's possible, the law says that you should try to do it. So this is, again, talking more about understanding the intent of the law as opposed to the letter of the law. And I just want to mention too, if you guys have questions come up, definitely drop them in the chat. And at the end, we'll answer them. So I can't see them right now, but we'll get to them at the end, and I totally welcome that. Okay. All right, here's the good news. And I know you're probably thinking, thank God, there's finally some good news, right? No one can promise you that you won't get sued. I know that doesn't sound like good news, but here's the good news. Even though no one can promise you that you won't get sued, what you may not realize is that you can begin building your defense to a lawsuit today with a comprehensive and proactive legal strategy. And not only can you do that, you must do that as an employer in California. The laws are completely stacked against us as business owners. They are not in our favor. I'm sure many of you have already learned that. And many of you will learn that this year, if not in the years to come. So the clock is simply ticking when this lawsuit is coming and when it's going to devastate our businesses if we're not prepared. So here are 3 ways. Here are the 3 ways to avoid a devastating door-closing employee lawsuit. This is the good news. The first one, focus on the foundation. So if you want to have a chance at sustaining a California business, you have to build upon a solid foundation. Many of us opened businesses and we grew quickly. And so we didn't get to spend a lot of time laying that solid foundation. And now we're either like, oh my goodness, I need to go back and do that. Or we've already been burned and we know we have to go back and do that. So to do that, we need to have legally reviewed, legally compliant employee agreements and offer letters. That means every time you offer someone a job, it's in a document that's been reviewed by your employment attorney, and you're not creating contracts where contracts should not exist. You need to have legally reviewed and compliant policies and procedures. There are a whole stack of them that have to be given by law to every single employee on their first day of employment. Do you have those? And then every year they get updated and changed. You should have job descriptions and employee handbooks created by an employment attorney and then reviewed every single year that you're in business for updates, because that handbook and that job description is really going to govern the terms of your relationship with your employees. So sometimes my clients will call me and ask me, Valerie, can I do this? And the first thing I'll say is, what does your employee handbook say? Not because I don't know the answer necessarily, but because that's our internal rules, our internal agreements as to how this relationship is going to go. And if we need to change that so that it accurately reflects our true intentions, what we really want, then we need to do that. And that's why we should review it every single year. So this is the foundation upon which everything builds. Having these things in place not only helps your employees understand their job and what is required of them, it helps to create a culture of accountability and clarity. And when your employees are working in clear fashions, like they know what their job is, they know what's expected of them, they perform better. And that means a better business for you. That means being able to sleep at night, being able to take time off. And I know we all want that. So this is the foundation, and that is how we get that. The second is to concentrate on consistency. So I had a former boss tell me once, we are what we repeatedly do. And I don't think she made that up. You guys have probably heard that before, but it's true, isn't it? What you do consistently is your practice. It's your habit, and it is the company culture. So I've met with new clients before who have, really bad situations in their business, and that's okay. That's what I'm here for. That's what I love to help with. But they'll tell me, that's not really who we are. That's not really our culture. But the thing is, if that's what is consistently being practiced, then it is your company culture. And that's what's going to be exhibit number 1 in the lawsuit that is filed against you, your company culture. If you have systems set up to consistently refer back to that employment handbook I was telling you about, if you have systems consistently monitoring your employee payroll, like I mentioned before, if you're consistently documenting employee conversations, consistently holding employees accountable for their performance, systematically documenting attendance, conducting reviews and employee meetings, then it removes a lot of ambiguity for your employees to come back and claim discrimination. It's the moment that we're inconsistent that we really open the door wide for employees to say that we're treating them differently for some illegal purpose. And if we have no set, consistent practices to rely on or point to, then they're probably right. Number 3, the third way that we avoid getting sued for any of these 5 things that I mentioned is to invest in a legal strategy. Most of us make the mistake of thinking that we can't afford a legal strategy. You see a lawyer here and you think, that all sounds nice. How can I afford a lawyer to help me with my business? But that's a mistake in thinking. We can't focus on thinking, how can I afford a legal strategy, when we've seen all of the facts and all of the numbers and all of the potential for the lawsuits that are coming our way. Instead, we have to adjust our thinking, and we really need to be thinking, can we afford not to have one? In California, when the laws are stacked against us, can we really afford not to have a legal strategy, right? So we even heard that 1 in 2 business owners will get sued this year. And just because we're human, we tend to think, oh, that won't happen to us. But maybe it won't happen this year. We only have a couple months left, right? But what about next year? and the year to come and the year after that. Every year that we believe this can't happen to us is another year of evidence that will be used against us in our lawsuits. It's not a matter of if we'll get sued. The reality is when we'll get sued and how badly it will be. So I warned you at the beginning, I was going to challenge your thinking and your previous approach to how you handled problems, right? Given everything that we've explored together, all of the facts, all of the stats, again, we really have to change that approach. We really have to provide new solutions to old problems if we're going to survive. When all of these laws in California are pro-employee, not pro-business owner. So you cannot fight legal problems with non-legal methods. Only a legal strategy will suffice. So what is a legal strategy? Well, a legal strategy is the single decision smart business owners make to protect their business from devastating, door-closing employee lawsuits. Here's what a legal strategy should encompass. Number one, it should mean building a strong foundation. So we spoke about this, and this is really where we start. Every business owner needs to have that strong foundation of comprehensive, clear policies, procedures, contracts, agreements. This is our evidence in court to defend yourself. These are also the rules that govern your business. So your business has to be built on top of these. A legal strategy means wise counsel. So dedicated, experienced business owners, specific support that you can turn to run fact-based scenarios by, gain insight and counsel on tough situations, and approval of termination. So you don't need to do this alone, nor should you. So think to yourself, who do I currently turn to ask for their legal advice to terminate someone, to ask them if I'm going to get sued if I make this action? The third is systems. A legal strategy means systems. And these are internal systems that really build on each other. They provide layered safety nets so that one single act by you or a non-act by you doesn't crumble the entire business. There should be layers of protection for you. And then lastly, a legal strategy is peace of mind. So by relying on professionals, you're relying on our experience, our knowledge, our skills, and that should bring you peace of mind. And so that's what you should really expect with a legal strategy. Okay, so here's the numbers. Here's the breakdown. All right, it costs on average $50,000 and up to settle a lawsuit. It costs $150,000 and up to defend yourself in a lawsuit. It'll cost $300,000 even if you win a lawsuit, because the attorney's fees will be high and you will have to pay an attorney to help you with that. Not to mention the stress and time. It'll cost $300,000 if you lose, but the potential, as we saw previously, is really up into the multi-millions. Remember, having a legal strategy in place now is all about having the ability to reduce the amount a lawsuit will cost you later and the fallout from it. It's the difference between losing everything you and your family have worked for to build this business or not. So investing in a legal strategy with San Gabriel Valley Law looks like this. This is something that we do for our clients. It's up to 4 hours of dedicated legal advice and strategy per month from a California employment lawyer who pairs practical human resources principles with legal advice. It's flat monthly fees and no hidden costs. It's direct attorney access who will learn your business, see the pitfalls coming, and advise you accordingly. It's an annual comprehensive compliance business audit, which is included, and it's special projects and services. Now, a lot of owners, they think that they can't, or they really can't afford a full-time HR person on staff, or they're working with maybe an inexperienced HR person, or like a lot of us, they have an office manager who kind of turned into HR just through being in the business that long, or some are even trying to rely on their CPAs to cover multiple areas of the business. I get it. Our plans are really created to be accessible for the average California business owner. So what do you think? What would you rather invest in, a lawsuit or a legal strategy? This is my favorite slide. This is my grandparents. In 1968, they opened a small corner store off Pasadena Avenue near Lincoln Heights with the dream of supporting their family. And this picture was taken about 20 years prior at their wedding. The corner store provided income for my grandparents to financially support their 6 children and the flexibility needed to logistically support such a large family. Although back then it wasn't that large, right? Nowadays it is. Back in 1968, laws were much different, but legal protection was not accessible to them. And because of that, they were taken advantage of many times, eventually resulting in the loss of their business. I would venture to guess that most of you are probably a lot like my grandparents and like me. You have a dream and you have a goal of owning a business that can provide a life for you and your family, and hopefully even a legacy once you're gone from this earth. At San Gabriel Valley Law, our goal is to make excellent legal protection accessible to the average California business owner, like you, like my own grandparents, and like me, so that business owners can run their business with confidence and peace of mind that they're protected. If your dream is like my grandparents, to build a business and a legacy your family can rely on, please don't wait to lose everything that you've worked for in one devastating lawsuit. You can visit our website or call us and schedule an appointment with us to get your legal strategy set up and in place this week. Get your business protected, get some peace of mind. So I'm going to drop a link in our chat to schedule that session with me. And then you can see here all of our information. You can feel free to screenshot it. And then we can take some time for Q&A. Thank you guys so much for listening.
Well, thank you, Valarie. Thank you, Valarie, for an absolutely fabulous session. I know a lot of business owners are, kind of worried about where they're at, where they're going to go to. Most importantly, is your office bilingual?
Yes, we do have staff that are bilingual. Yes.
Okay, great, perfect. Because that sometimes there's a language barrier and folks are embarrassed, or their significant other is, in charge of the business, but they always say, pero no hablo inglés. We don't want that to be a reason for them not to reach out to you. But let me go through some of the questions that were posed on the chat room. So I'll start from the top. Let me see. Let me go here.
And let me just say, sorry, I have to say this before. So if your question is really specific to you, I'll ask that you set up a session with me, because I won't be able to give legal advice on the call. But if it's general, I'm more than happy to answer that.
Okay, so what we'll do is I'll run through each of the questions, and then you can say, can you please contact me? And then that way we can move on to the next question. So we have Olivia Cerna, who's asking, what is LAWtinas?
Hi, Olivia. I don't know if you remember me. We've met before. Thank you so much for being here.
I do, Valerie. Thank you.
Thank you, Olivia. Thank you so much. So LAWtinas is the agency that basically governs employee safety in the workplace. So they're the ones who are coming down with all of the vaccine sort of, not the mandates, but the requirements, what you have to do, what you can't do. And then prior to COVID, all of the employee safety training. This is really important in every industry, but especially industries like construction, there's a lot of safety requirements.
Okay.
Good question.
The next question is from Glundy. Can you explain break times or full times and part-time employees?
I don't know if I fully understand your question. Do you want to come on and
Yeah,
maybe
Glundy,
give
can you
people-
come on, please?
Yes, hi. Great information. I've been learning a lot, but my
Thank you,
question is
Glendy.
more, I have part-time and full-time employees, and after how many hours of work can they take their break time and their lunch time? I know it's after 5 hours, but for the part-timers, especially, what will be their break time?
Yeah, it really just depends. It depends how they're being paid, what industry you're in, and really the nature of their job. Why don't you set up an appointment for me and let's talk about it? Because I'd like to be able to give you specific advice to your specific workforce.
So it's by hour in a restaurant.
Oh, in a restaurant? Yeah, that's a big challenge because you have a busy operation, right? So for every 8 hours that someone works, they need an uninterrupted meal break. But again, let's talk about it because this is specific to your situation. So I want to make sure that I can help you with that.
All right, thank you.
Thank you, Glendy. Thank
And
you.
then we had Irma L. Martinez, who explained OSHA is the California Occupational Safety and Health Administration. And the next question is from Rick Rodriguez. What is SOL on wage and hourly claims? And how far back does a court look to determine damages?
SOL, statute of limitations. Oh, it depends. I read SOL as something else. Forgive me. It depends on your jurisdiction. So it's typically 3 years, but it really depends on the jurisdiction. And then the second question was,
and how far back does the court look to determine damages?
So typically 3 years, but it can be more.
Okay. The next question comes from Angelica Urigio. What changes will we see regarding independent contractors in 2022? We professional services and PR marketing. Most of our ICs may also be working on projects aside from the work they do for us.
Thank you, Angelica. That's a really good question. We're gonna see a lot of changes in this area as we have throughout the year. As I mentioned, this is not favored by California law. So many are anticipating that this will go away completely, independent contractor status. I don't think it'll go away completely because the law does carve out exceptions for certain types of people. It's just not the typical ones that are using it. So that's why in this area, if you're using independent contractors, it's really important to get their position analyzed based on the 2 to 3 part legal test that I mentioned. So you can make sure that you are compliant, and you may be. And so if you are, then you should do it. But it's really, that's kind of the unknown. You want to make sure that you're totally compliant in that way. Because the law is moving away from it, you don't want to kind of get burned by it as it moves away.
Okay. All right. Thank you. Amy Williams shares, what a great session, Valerie. Great job.
Oh, thank you.
Angelica repeats a great presentation and delivery.
Thank
Jen
you.
Carter, awesome content, Valerie.
Thank you so much,
have
you guys.
Roberto Corral, thank you for the information. Carolina Bunye, terrific session. And Joel Pulgarin, thank you, Valerie and Gina. Angelica asks, is there someone on your team that can also work with us on solidifying various business documents, i.e. team agreements, non-disclosure agreements, independent contractor agreements?
Yeah, definitely, Angelica. That's something that we do as well. We help all California business owners. So that's everything from startup to operation. And so that is absolutely something that we do for our clients. So I dropped a link in there. Please schedule a consultation with me or screenshot this screen, and you can do it by any of those avenues as well.
Okay, well, thank you. Next question from Moses and Kimberly Gomez from South Bay Iron. How should we handle an office cleaning company? Can we 1099 them and handle as an independent contractor?
Good question. So that goes back to Angelica's question of it really just depends. And I really want to point out something for you guys. It may sound like I know I gave my disclaimer about not answering because I'm not giving legal advice. It may sound like I'm hemming and hawing, but it's actually a good thing that I'm not giving you sort of a hard and fast answer. Because of the 2 to 3 part legal test, it really requires an analysis to see if these positions comply. I would need a lot more information than that to make sure, but that's what your employment lawyer should be doing for you. That's the only way to be protected. Anyone who will tell you, oh, just have them sign a contract, they do not understand the law in this area. That is not how it works. So it's a good thing. So it really just depends, Moses and Kimberly, but I would love to talk to you about it more to help you and make sure that you're doing it right and doing it well.
Okay. The next question comes from Leslie Hunter. How much is your retainer per month for a company with 50 plus employees?
Hi, Leslie. Thanks so much for that question. Our goal is to make legal services accessible. So we do flat fees, pretty much all flat fees, no real hourlies, and then we do monthly subscription fees. So there's no guesswork as to how much you're going to get paid every month. It's not hidden, but we have some plans that start as low as $2,000 a month. So if you have 50 employees, you need legal counsel. Give us a call, please.
Next question from Moses and Kimberly Gomez. What is needed for an employer to secure for non-US citizens?
Ooh, that's another big question. I'm sorry, you guys. That's a big question with a lot of different answers that I would have to talk to you in a session.
Okay.
Yeah.
Leslie Hunter asked again, how much is your retainer per month for a company with 50 plus employees? So you've answered that question. The next one is from Roberto Corral. Do you handle cases where an unvaccinated minor isn't allowed to go to school in person until vaccinated? The parents won't vaccinate him due to religious reasons.
No, that wouldn't really be my area. It depends sort of who's not allowing him to go to school. It sounds like it might be a family law situation, but I have a lot of colleagues who could help you with that, and I'd be more than happy to refer you to someone. If you want to email me at that email on the screen, I'll definitely refer you to someone.
Okay, thank you. Rebecca Gomez, thank you. Appreciate the info. LAWtinas, I love it. I'm just waiting for my bar results, but thank you for this information.
Oh, wonderful, Rebecca. Send me an email. I'd love to get to know you.
Next question from Glendy. Are businesses required to maintain a copy of every paycheck given to employees?
Oh, good question, Glendy. Not every paycheck, but payroll records, yes. And there's a specific way they have to be kept, like in the format. And then every paycheck has to have specific language on them. Your payroll companies are hit and miss. Sometimes they'll tell you, oh, we'll take care of it. But most of the time they require you to tell them what to put on it. But many times we don't know. So let's talk about that because I can help you with that. And
then the last question is, if we would like to be proactive with our business and hire your firm, what exactly are your services?
Thank you for asking, Joanna. So we specialize in helping California business owners. That is all who we help. A lot of firms also help employees. We do not. We only help business owners. That's who we're passionate about. And so to do that, we specialize in people with employees and independent contractors. So if that's you, we can help. We offer flat fee subscription services where you can call us every month and we can partner with you, learn your business, audit your business, point out all of the pitfalls that are coming and help you bring it to compliance before it gets out of hand. And then we also do special projects. So we can create your employment contracts or your other business contracts. We can analyze your compensation structure, make sure that you're paying people correctly. We can do your training and your harassment training. Anything that has to do with your employees, we can do. But I think the biggest thing is that we don't expect you to know what that is. Every single relationship, we start with an audit. So we'll tell you what we think you need to do. And I mean, you can do it or not, but at least you have a roadmap for what needs to be done and a timetable for priorities.
Okay. Well, all right. I think we are set to go. Okay. Well, thank you very much, Valarie, for your time. And I want to thank everyone for their time. I'm sure you all had an opportunity to take a photo of Valarie's information. There's some really great golden nuggets, and I'm glad we were able to do this for the first time. And I want to thank you and appreciate you. And Daryl, would you like to say a few closing comments?
Can you hear me now?
Yes.
Perfect. Thank you so much, Valarie. I mean, this is very educational. I've learned a couple of things, and we'll probably be giving you a call in the incoming year and stuff like that. But thank you so much for sharing your knowledge to all of our Zoom friends. But anyways, I'd like to everybody just have a great day. What's left of it? Happy Tuesday, right?
Yeah.
All right.
Okay.
Thank you, guys. Thank you so much,
Thank you, everyone,
Olivia,
for your participation. And if you need more information on this recording, you can reach out to me, Olivia at LALCC.org. Our office number is area code 213-422-9019. Have a blessed day, and thank you.
See you later.
Thank you.
Bye, Val. You did
Bye.
great.
Thank you.
Bye.
Bye, Olivia.
Bye.